Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
Nice to see so many people on the presentation here this morning. I know it's a popular topic, and that's why we do like to do this presentation fairly often for groups of managers and owners as well. For those who may not be familiar with me, my name is Dan Wasserstein. I'm a community association attorney. All that I do me and the other attorneys here in our office is represent associations. We don't do a little of this and a little of that. 100% of our practice is dedicated to the representation of associations. So we have a lot of experience. We focus on a lot of responsiveness and accessibility and also education with programs like we have today. So like Ashley said, I will go through the presentation. She'll periodically stop me and present some of the questions that you have so that we can break it up a little bit. And then at the end, we will take some more questions as well. So if you do have questions, if you would put them into the chat that is, or into the Q&A, either one, I believe, should suffice. And we'll go from there. So to begin with, let me get my screen shared here. All right. So we are ready to rock and roll now. All right. So this is the violation and fining process is the title of the presentation. And we're going to start at the first slide here. So for each owner, tenant, and guest, they're governed by a series of things. The Florida statutes, the declaration of covenants in an HOA or declaration of condominium in a condo, the bylaws, the rules and regulations. I don't put the articles on this list because generally they don't really have guidelines for the behavior of your residents or guests. So we generally don't put that on the list here because the articles are usually just explaining how the corporation was originally set up. These are the main sets of laws that govern the behavior of people within your community. So that's what are important that you're making sure there's compliance with. Now, some of the specific types of covenants or restrictions that we commonly have enforcement issues with are what you see here. Architectural standards and alterations. Of course, more common in an HOA when it comes to architectural guidelines. But those are things like, people painting their house an approved color, not enlarging their driveway bigger than what's allowed. And of course, asking for approval and getting it before they go ahead and do these projects. Even if the project is an approved color or an approved material, they still need to go ahead and get that approval in writing before they go ahead and do that. We installed a generator at our house. We, of course, knew the generator would be approved, but we couldn't start that process until we got the approval of our HOA, or we would be in violation. So again, architectural and alterations to the parcel. Pet restrictions is a big one. We all love our favorite emotional support animals and service dogs. Everyone loves dealing with that. But there are restrictions, not on just pets, but on animals. And a lot of times the pet restrictions apply when it's not a support animal of any sort. But even other restrictions can apply on animals to ESAs and service dogs. And those are things like cleaning up after the animal when it's outside of the unit, making sure it's walked on a leash and kept under control is a big one. And also, of course, that the animal can't be a nuisance to others, barking, biting excessively, those sorts of things. So again, those are things where we commonly have to take enforcement effort, or I'm sorry, you commonly have to enforce. Restrictions on leasing and sales, I think that's pretty self-explanatory when people are, not following your guidelines and your restrictions on leasing. Again, and you have violations there. Parking and vehicular restrictions. We have rules in communities. You can have certain type of vehicles. You can't have certain type of vehicles. You can't park on the street. You can only park these many in the driveway. The owners can't park in the guest parking. Those are just some examples of common sort of parking and vehicular restrictions that we see that are enforceable, and that you would want to enforce either through the fining process, as we'll discuss here today, or other enforcement methods. And then finally, nuisance and noise complaints. Obviously, that's more along the lines of where, you know, you have neighbors who are just not being respectful of the community, and you need to take some action. So those are just some of the most common examples of enforcement issues you may have, restrictions that you need to make sure people are abiding by in your community. Now, how do you achieve enforcement? Who does that? Well, it's primarily through the board. The association and the board members have a duty to enforce the governing documents and to do that uniformly. And I say the uniformly, I stress that because that's a very important word. And we'll see later when we talk at the end of this presentation about common defenses that owners raise. One of the most common defenses is when there isn't uniformity in the enforcement of rules and it's more haphazard. So you want to make sure you're uniformly enforcing, because not only is it important that everyone's treated the same, but also if you're not enforcing over time, it could result in a waiver or forfeiture of rights. So again, it's important to make sure you're diligent with your enforcement efforts. Now, when it comes to fining, and that's what we're talking about today, there's other methods of enforcement, but for today's purpose, we're talking about fining. For condos, the statute is 718.303, and it allows a condo association to levy a fine against an owner, a tenant, a guest, or invitee. An invitee is someone that you would allow on your property, like a contractor, for example. Quite honestly, I don't know why an association would want to fine a contractor. I don't think they're going to I don't think the contractor is very likely to pay you, but you really want to go after the owner. Even when it's the tenant's behavior, the person you want to fine is the owner. And as you see in the second bullet point here, the way the statute's been modified over the years, the argument is that you don't actually need authority in your documents to avail yourself of the fining statute. Your documents just need to be governed by Florida statutes, the current Florida statutes. And if they are, it's ideal that you have somewhere that it says that you have the right to fine your owners. But because of the way the statute's been modified over the years, there's an argument that you don't even need that language in your documents. Again, I highly recommend that you have it, though, at least in the rules, because inevitably, when an owner says, show me where it says you can fine me, rather than saying, well, the statute says such and such, it's great if you can point to your community's rules or governing documents and say, here it is right here in black and white. Then you don't have to have this legal argument about the statute's application. For the the HOA statute, very similar as far as the authority to fine. It's in 720.305. And again, it's basically the same set of people who are subject to fining, and the same argument with the language being in your governing documents. So what I would say, again, make sure, ideally, if you don't even have it in your declaration, you should at least at a board meeting just adopt a rule that says that you follow and will enforce fines based on the current version of the Florida statutes. So,
hey, Dan, we have some questions here if you want to take a few.
yeah, sure, let's do it. Do you want to read them? Go ahead.
Sure. Yep. Can an HOA's documents establish a violation of something that the state of Florida and or county governments permit?
Absolutely. So we see that all the time. People will say, well, I'm allowed to have a dog. I'm allowed to have a 100-pound dog if I want. The county doesn't stop me. The county allows me to have that. But the HOA says no. That's one of the most quintessential bases of living in an HOA, is that you give up certain rights If you're not in an HOA, you can paint your house whatever color you want. So yeah, there's plenty of rights that are the local government or state governments either silent on or specifically permit. But the HOA documents can override that because the documents are like a contract between the owners and the association. So the HOA covenants can, in many instances, be more restrictive.
And can an HOA fine if they don't have Kaufman language in their documents? Fining was added in the bylaws by a vote of the board.
That's a specific question to Joanne's community. You can, if you don't have Kaufman language, you will want the authority to be in the governing documents. So in that example, it sounds like the board did amend the fining right into the bylaws. I'm assuming the board had the authority to do that. They didn't need a member vote. If the board properly amended it into the governing documents, then you don't need the Kaufman language because your governing documents themselves give the authority. You really need the Kaufman language if your governing documents are silent as to any fining.
And let's do one more. If you have a condo association within a master association, can the master association handle, it went away because someone else answered one or put one. Can the master association handle the violations for the condo association?
It depends how your community's set up. Some masters are set up where they have the right to enforce the sub's documents, but generally the sub association has to enforce their own documents. Again, it can be delegated. We have a client where the master has agreed and the sub associations are willing to assign their enforcement rights to the master. But you really need to look at your documents, and usually the association that has the governing document that has the violation that the owner's in violation of, usually that's the association that needs to enforce it. So if they are violating your condo declaration and not the master declaration, usually it's the condo that would be enforcing it. Again, unless your governing documents for your community delegate that authority. But again, that's kind of a community specific question.
And you know what, real quick, we have a few people on here asking, what is Kaufman language? Can you just do that real quick? Yeah,
sure. Kaufman was a case in 1979 that said and I'll spare you the details of it, but basically what it stands for is that if your governing documents don't somewhere have in them a statement that they're subject to the Florida statutes as those statutes are amended from time to time, and that as amended from time to time language, that's the Kaufman language, the magic words. So if your documents say our community is governed by Florida Statute 720 as amended from time to time, that's the Kaufman language. And what that means is your community automatically absorbs and is subject to all the changes that the legislature makes to the statute year after year. It automatically updates. But if you don't have Kaufman language, then certain rights and substantive rights that are added to the statute over the years are legally not enforceable because you're not automatically absorbing those. So again, that's a question for your condo or HOA attorney. With all these new laws that have gone into place, especially for HOAs, we are getting a lot of questions on whether those new laws for vehicles and parking and trash cans and things like that, if they apply, and it's an HOA by HOA analysis to see if you have those magic words, the Kaufman language, or not. So that's kind of just an overview of what that is. Okay.
Perfect.
All right. So we'll go back into this here. And again, please, in a few minutes, feel free to, we'll go through some more questions. All right. So we've talked about sort of what are the things that are enforced, who enforces them, and how can they be enforced? Now we're moving on to, okay, let's go through the steps of the process, right? So the first step is a violation is brought to the attention of the association. Who does that? Well, it can be by management, most commonly. A lot of times management will do rounds on the community. There might be an employee, a management company employs to do that for many associations. There might be an assistant or a committee member, but usually it's management. Also, it can be other owners, tenants, board members, and as I mentioned, committee members. Anyone in the community can bring a violation to the attention of the association. Once that is brought to the attention of the association, there should be information gathered. You shouldn't just jump to sending a letter. You're going to want to make sure you confirm, especially if it's brought to you by a neighbor or a committee member, your management or your board, you're going to want to confirm that violation is accurate, that it exists, that it wasn't something that was only for a fleeting moment. If it's like, let's say a parking issue that was resolved after only a couple of minutes, you want to look into that. Make sure, okay, is this something that is actually existing? Is it something, maybe if it was only a quick violation, is it something that this person has done before? So you want to look into the history, the person, the violation, and if there is merit, then usually a violation notice will be sent to the offending party. It should identify the behavior, the rule or covenant that it violates, and also it should indicate what's necessary to cure that violation if it's something that's ongoing. It's also good if you can to include a photo if it's a maintenance or parking type of thing, or a dog off a leash, if you have photos of those things, because a lot of times we will see owners that say, oh, it wasn't me, it wasn't my car, I didn't do that, my house isn't, my roof isn't dirty, my car wasn't parked illegally, my dog was on a leash. And if you have a photo that you can embed right into that letter, it's pretty hard for that person to refute that. So that's the start of it. And again, these are sort of like a warning type letter we're discussing right now. So as you see here in the first point, we say if the violation is the type that's continuous as opposed to one-off, the offending party can be given the opportunity to cure with a certain number of days without penalty. And that is very common, that when you get a violation reported, the first thing you do is you send a warning letter. My wife and I got one last week that was the sidewalk that we're responsible for needs to be power washed. They gave us 30 days to do that. So it's very customary that associations, when there's maintenance type issues or ongoing type issues, they will give the offending party some time to address it without penalty. Now, keep in mind, you don't have to do that. But I would tell you it would be very draconian, as us lawyers say, to not give a window of time for people to do that, unless, of course, this is a repeat offender here. But usually you want to give that time. Now, there's other types of violations that are not continuous, and it's not ongoing. And you do not have to, of course, give a warning. Like, let's say someone, the dog off a leash example, or parking illegally, or the best example is someone has a party that is blasting music in a condo unit till 4 a.m, waking up all the neighbors. That happens, and then it comes to a conclusion. So those aren't things like maintenance where there's this opportunity to cure. Those are what we call one-offs, where it happened and it's over. So when you have a one-off, or it's an ongoing violation and the time you've given the person to cure has passed and you've double checked and they haven't fixed the issue, that's usually when you would go to the next step, which is a board meeting to determine if the board's going to impose the fine. The board would do that at a properly noticed meeting. There should be fining listed on the agenda. And we advise that you list either the unit number or the lot number or address on the agenda. They should also be referenced in the minutes of the meeting to identify who's being fined by the board, what they're being fined for, and how much they're being fined for. Now, interestingly here, we see a note. This is new for this year. For HOAs, they're not allowed to fine or suspend an owner's rights if they leave garbage cans out for more than 24 hours after the pickup time. So some communities used to issue a violation if the trash pickups in the morning and the trash cans were still out at night. They would issue a violation. That's no longer permissible under the current version of the HOA statute. And also with regard to holiday lighting, now it says in the statute that it's not a violation, even if your documents say, let's say the Christmas lights are supposed to be removed by January 10th. It used to be that on January 11th, you could issue a violation. Well, now on January 11th, you could send the owner a notice that says they're in violation, and only if they're in violation for another week after that notice would you then be able to violate them, or I should say levy a fine against them for having those holiday lights up longer than they're allowed. So the law is giving a little more leeway on the trash cans and on the holiday lighting. And again, that's only HOAs, not condos. So as we talked about, the board meeting where the board levies the fine is a normal meeting, 48 hours on the agenda. Generally, it's going to be a maximum of $100 per violation, up to $1,000. The board does, especially in an HOA, have the ability to go beyond those numbers if you amend your governing documents. But generally speaking, it's $100 per day, or if it's one of those one-offs, $100 per incident or occurrence. And if it's continuous, it can go up to $1,000, which is the maximum permitted by default under the statute for a fine in either a condo or an HOA. Again, I say that by default. Again, you can have your documents amended to have higher numbers, but generally speaking, those are the numbers. And importantly, the board is the one that determines the dollar amount. No one else determines it. So we've gone through step one, which is the warning letter. Step two is the board meeting where the board levies the fine. One of the questions we get is, well, do we have to have a board meeting if we already have what I call a menu of charges, that if you don't paint your house, it's $100 a day. If you leave the trash out too long, it's $25 a day. Some boards will say, if we already have that defined, do we still have to have the meeting? The answer is absolutely yes, you have to have the meeting. While that list of charges helps you to uniformly fine people so that different people aren't getting fined different amounts for the same issue, it does not substitute for the board meeting. You also can't delegate the board meeting to the manager. The board has to meet. It's very clear in the statute, and it's been clarified over the last 2 years that the board has to meet. So that's step two. So now once the board's levied the fine and determined that dollar amount, that's when it goes to step three, which is the fining committee. Before it can go to step three, though, there has to be this 14-day notice. We call it a 14-day notice. It means at least 14 days. You have to give the owner or the person being fined a warning that says, hey, you were fined by the board X amount of dollars for this issue. But before we're going to impose that fine against you, it has to be approved by the fining committee. And the committee meeting is going to be held on such and such a day at such and such a time. And that notice also needs to explain not only where and when that meeting is going to happen, but how the owner or the other person being fined can fix the issue, if it is a curable issue, before that fining committee hearing. So, hey, here's not only what you did wrong, here's what you can do to fix it. Now, just keep in mind, under the new statute, you used to be able to schedule that committee meeting. You could wait months and months if you wanted to. Now, most associations didn't, but you could put that on the back burner, and 6 months later, you could have the committee meeting and send this notice to the owner. In HOAs now, under the new statute, the meeting has to be within 90 days of the notice. So you want to make sure if you're going to send that notice out of the 14-day notice, you can't schedule a committee meeting for 6 months away. It's got to be within 90 days of the 14-day notice. So again, that's for the fining committee. Now, the role of the fining committee has been clarified over the last several years. It is that the fining committee is only empowered to review and approve the fine levied by the board. The committee does not have the power to modify it, to extend time, or anything like that. It's just purely listen to what the board did, look at what the board did, listen to the homeowner, and then decide either thumbs up or thumbs down. For anyone that's seen Gladiator or any of those types of movies, you know, when it's the end of the fight, the emperor either gave an up or down. There was no in the middle. So that's how it is with the fining committee. The fining committee has to consist of at least 3 people, 3 members, but they cannot be officers, directors, or employees, spouses, parents, children, or siblings of an officer or director. So the idea is that this committee, if it's going to be, let's call it a second look at the fine, obviously, if I'm on the board and my wife is on the committee, there's a pretty good chance she's going to rubber stamp whatever I voted on. So that's why we want the fining committee to be some other independent owners that are not affiliated in these ways with the board members or the officers. And that makes sense because, again, otherwise it would kind of make this two-part process really not valid. As I said earlier, the fining committee, they can only give the thumbs up or thumbs down. If the fining committee does not approve the fine levied by the board, it's not imposed. Now, that doesn't mean that the board can't restart the process and try again to get a fine levied. It just means that that violation and that fine are not imposed. And if the board wants to revisit it, and if the violation has not been cured, then the board would have to restart the process again from step 1. For condos, once the committee's made the decision, a notice would be sent to the owner, and the payment is due not sooner than 5 days from the date of the notice. Now, again, new HOA statute. First of all, whether the decision is thumbs up or thumbs down from the committee, you now must send a determination letter within 7 days of that committee meeting. And instead of the fine being due not sooner than 5 days, now it's 30 days. So the owner gets a letter after that committee meeting that would say, let's say, either the fine was denied, or more commonly, the fine was upheld. But now instead of saying it's, becomes due and owing 6 days from the date of this letter, now it's 31 days from the date of the letter. Why is that important, that extended period of time? Because again, new legislation for HOAs, if a violation is cured at any point in the process, even that 30-day window when that letter of determination is sent, the fine cannot be imposed if the owner cures the violation. So you can go through all these steps of warning letter, board approves, levies a fine, you send the notice to the owner, you have the committee meeting, the committee upholds the fine, 30 days go by. On the 30th day, the owner, let's say, cleans their sidewalk. Guess what? Fine goes by the wayside. Now, one of the questions we've been getting is, well, what about violations that aren't maintenance, that can't be cured, like that cure themselves? Like I said, the dog off a leash. Well, the dog goes off the leash, and then 10 minutes later, the owner brings him in the house. The violation is over. Well, by a strict reading of the statute, one could say, well, they cured the violation. I don't view it that way, and a lot of my colleagues don't view this new statute that way. For those types of violations, again, the ones we call like a one-off, or ones that aren't ongoing, but they naturally come to an end, the trash cans, parking, the dog, these things happen and then they naturally resolve themselves. If the cure, meaning the moving the car, bringing the dog in the home, etc., if that was a cure, then that would mean you could never fine under this statute for those types of things. So we look at that new provision about curing a violation, making a fine go away. We look at that only in the context of things that are really curable, which I refer to mostly as maintenance type issues, a dirty roof, an unpainted house, someone that leaves junk on their balcony that's not supposed to be there. Those are the type of things that, okay, if they fix it and it's an HOA, then fine. In those instances, it can go away. But remember, some of these new laws here, and I made clear to put it that it's for HOAs, everything you see on this page, only for HOAs. All the original items for condos still apply. Only in HOAs are we getting this litany of special treatment. And the reason for that is, some of you may have heard, there was an association in Miami-Dade called the Hammocks, that people on the board and on fining committees were behaving very wrongly and criminally. And so their legislator put forth all these new laws having to do only with HOAs. So there's a lot of times people saying, why HOAs, not condos? Well, because the legislator that brought forth this issue was dealing with this problematic HOA. So when he presented the new legislation, he only wrote it for HOAs. I look at it like, if it's going to be for one, it should be for both. But in this instance, it's actually better it's not for both, because condos still have better fining rights that are not as constrained. Finally here, for HOAs, if you have any attorney's fees that you incur throughout the fining process, they cannot be imposed unless it's past the 30 days from that determination letter and the owner still has not resolved the issue. That's when you can then assess any of your attorney's fees against them as well. But again, that's just for HOAs. So again, a lot of nuance now for HOAs, a lot of additional procedure, limitations, and the biggest issue I would say for fining that came out of this year's update for HOAs is this issue where if they cure the problem, the fine goes away. In my own legislative update, some of you may have read, I don't agree with that. I think it takes away from the deterrent effect of fining, but that's a conversation for another day. So you got these fines that you've levied, and let's say the owner hasn't fixed it, they're legit, they owe the money. Well, what the heck can you do with these things? Well, not a lot sometimes. First, they can't in a condo ever be used as a lien. So if you're in a condo association, you have fines, you could have $1 million of fines against an owner. If they don't pay them, you can't use the lien process to collect on them, which really takes a lot of teeth out of them. You'd have to file a lawsuit. Or more commonly, when the owner sells their condo, they would be paid from the estoppel at the closing. In a HOA, it's very similar, except that if a particular violation that's ongoing gets to $1,000 or more, if your documents authorize more, you can then lien for that if your documents allow for it. So in a condo, never a lien, no matter what the documents may say. In an HOA, if your documents say that a fine can be treated the same as an assessment, that's great news. And if an owner gets to that $1,000 mark on a particular violation, you absolutely can go through the lien process for that. So that's gives a little bit of teeth in an HOA to fining. What else can you do with these fines? Well, you can suspend common amenity access, common area access for certain areas. You can suspend voting rights. In an HOA, if they owe a fine, they're not allowed to run for the board. Can't be a candidate for the board of directors. And if there's someone who's already on the board, whether it's in a condo or HOA, if they get fined and that fine is pending for more than 90 days, they give up their seat on the board. So there are some sort of I'll call them non-monetary punishments where you can suspend rights or prevent people from being on the board if they owe fines. Now, what we're talking about suspension of rights. Well, what can you suspend? What can and can't you suspend? Well, if they owe a fine, you can suspend amenity use rights. Amenities most commonly your pool, your gym, the laundry room, the clubhouse. Those are the sorts of things you can suspend the rights on. What doesn't a suspension of rights apply to? Common areas that are used to provide access. So if an owner needs to walk through the lobby of a condominium building to get to their condo, you cannot suspend their right to use the common area lobby. They need that to get access to their unit. Another item, means of ingress and egress. So if an owner is coming in and out, let's say in an HOA, you cannot prevent them from coming in. Now, one of the questions we get a lot is, what about suspending their transponder, meaning they have to go through the guest lane? Well, it's a very controversial remedy because of the way the statute's worded, but there are also arguments in favor, the way the statute's been changing over the years, that arguably do allow an association to justify turning off a transponder when an owner owes a fine or any other monetary amount for more than 90 days. So again, that's something you would talk to your association attorney about, but it was highly effective, but a little controversial if you're going to push people to go through the guest gate. We once in a condo had people with that same logic say, well, if an HOA can suspend the resident lane and make them use a guest lane, why can't we suspend their elevator use rights and make them take the stairs to get to the condo? And while I like the idea and the thought, and I see the analogy, there's no way that would be upheld, just given how much more cumbersome, especially in a high rise, it could be to make someone take the stairs. But a good thought. Another item you can suspend, most commonly, utility services. Some condos and other HOAs, the water is paid for as part of the assessments. And some communities will say, well, can we turn off their water? The answer, no, you can't turn off their water if they don't pay a fine or other amounts. One of the other things some communities have the ability to turn off is cable and internet. However, again, highly effective, highly controversial, especially internet after COVID now, when we're post-COVID world, a lot of people use internet as their means of working. So it's being perceived more and more as a utility than a luxury. So internet is one that I would, even if you have the ability to cut someone's internet off because you have, let's say, a bulk telecom contract, I don't recommend doing it. Also, a lot of people, especially in some of your 55 plus communities, they use landlines, and those landlines might be something that they use to, let's say, have medicine deliveries or call 911 in an emergency. And if their landlines are internet-based services, you do not want to cut those off. So just something to be mindful. And then, of course, vehicular and pedestrian access to the lot, meaning the owner's property itself, and the right to park. So you can't take away someone's parking space either. But a lot of other amenities you can take away. When it comes to suspensions for non-payment of a fine or other amounts owed, not only can you suspend amenity rights, you can suspend voting rights. And voting rights, especially in a condo, there is a little more procedure you need to go through. I won't go through the detail of it here, but it's listed there for you to see. But you can also suspend voting rights for someone who owes a fine or other obligation for more than 90 days. So amenities and voting are both eligible for suspensions after 90 days under the statute. Now this is, and we're getting to the end here, and we'll take some questions at the end. This is the most important slide, I think, of the whole presentation. We've gone through this whole process, how you can do it step by step, and then what you can do with those fines, how you can collect on them, how you can enforce against people, either suspension of rights or voting rights. But what are the defenses? And this is where it's important. The first, selective enforcement. I'm sure a lot of you have heard that term before. Selective enforcement, where an owner says, you're treating me unfairly. Well, I've put 3 bullet points there because those are elements that have to exist for an argument of selective enforcement to hold water. So sameness, what does sameness means? Apples to apples. So we've had owners say, well, you're selectively enforcing against me because you made a parking violation against me, but my owner has landscaping issues and you didn't go after them. That's an example where parking, landscaping, apples and oranges. So they can't make an argument of selective enforcement unless they say, you're treating me differently for something that's exactly the same or highly similar than you treated someone else, but it cannot be totally different types of issues. Another element that the owners need to have for a selective enforcement argument is recency. We once in a 55 plus community had a woman argue that her 35-year-old child could stay in the unit by himself because 21 years before she knew that the board let another 30-something-year-old live in the unit by themselves. And again, a 55 plus community. So in that example, we told her, explained to that woman, you can't reference an instance from 20 years ago as selective enforcement now, 20 years later. The last element here is knowledge. So sometimes we have people say, well, you cited me for building a bigger patio than the documents allow, but my neighbor did the same thing. And sometimes the association is not aware of that. So in that instance, obviously for uniformity purposes, the association would want to pursue that other neighbor if they do indeed have a violation. But for things sometimes like that in the backyard, especially a patio that's flat on the ground, and maybe there's fencing up, an association doesn't know anything and everything that's happening, in the backyard of a home. So again, in that instance, even though it's apples to apples, patio to patio, if the association was unaware of the other one, then the owner that you violated can't claim selective enforcement unless, of course, you refuse to go after that other person now that you know they have a violation. So you remember at the beginning of this conversation, I told you all it's very important that you uniformly enforce your governing documents, and selective enforcement is the reason why. A couple other reasons why: waiver and statute of limitations, which are somewhat related to each other. Owners will sometimes make the argument that, well, you waited too long to enforce against me. And they can, they can be right, especially if you go past 5 years. Statute of limitations is a real defense. And if an owner has had a violation that the association has been aware of for 5 years or more, that owner has a valid statute of limitations argument, meaning they can say, I admit I did this violation or my property's in violation, but you've let it go for more than 5 years and you can't enforce against me. So something to be very mindful of. Waiver is a shorter term issue, and a lot of documents have what we call a savings clause, which says that the failure to enforce a particular violation is not a waiver of the right to later enforce that. But statute of limitations, if you let it go for too long, be very mindful that you could lose the right to enforce. And there's a whole other host of issues that then come with that for your community. The last and most common defense we get to enforcement of fines, and this is the big one, procedural missteps. You've heard today of the steps of how you go from sending a warning to a board meeting to sending a warning, a committee, 14-day notice. You got to have a committee meeting. After the committee meeting, you have to send a letter. And then in an HOA, there's all these time frames that go along with that letter. If an owner hires a lawyer, or even they themselves, but especially if they hire a lawyer, you can be sure the first things they're going to look for are show us the warning letter, show us the board meeting notice, show us the minutes of the meeting that the board proved the board voted on this. Give us a copy of the 14-day notice. In the 14-day notice, they're going to look at the content and make sure, does it have everything the statute now requires? Okay, show us the committee meeting, the notice of the committee meeting minutes. So if there's any mistake along the process there, or you don't have accurate minutes, or there wasn't a notice posted properly, those are things that will be fatal to your fine in those examples. And there's a case, an appellate case, that says that the fining statute, and quite honestly, the entirety of the statute, but specifically the fining statute, has to be strictly complied with. So that means that even if you say, well, we did everything else right, but we just made this one mistake, the case law says that that's fatal to your fine. So be very careful. This is, like I said, the most valuable page of the presentation. I will tell you, you want to be mindful, especially now with all these new laws. It's important to talk to your association lawyer, talk to your management company, make sure you're all on the same page. Of course, fining is just one enforcement tool. You can suspend, you can have a legal proceeding or a process where you have legal letters sent. I am seeing, just to share with you all, clients are becoming more and more disenchanted, I'll say, with the fining process. Yeah, I personally think the value of it is really in the threat. When someone gets that letter that initially says you need to fix this problem or you could suffer a fine, that's the value, because going through all this procedure, to me, it's very cumbersome. It always has been. The last few years have even eroded the value of it further and made it even more challenging, more landmines to avoid in the process. And now, especially for HOAs, they've made it easier for owners to sort of slip out of the process, even after months potentially of non-compliance. So, you may want to examine other additional enforcement options. Fining is still out there. It's still a good deterrent, but again, be mindful of these defenses and of the fact of how cumbersome it is. So with that, I know we got about 100+ questions here, so we'll try to go through some of them. Ashley, if you want to kind of maybe navigate through some of them.
Questions. All right, one that I saw on here before that I thought was pretty good. So what do they do if they're a small condo and they don't have a fining committee? What do you recommend?
The only other option is, I'm assuming they have an association lawyer, that would be after the management company sends the warning letters to owners, you could still warn that a fine may be imposed or a suspension may be imposed. There's no problem with legally threatening that, because they could at any point get a committee, but the reality is they can't follow through with it without a committee. The law does not make an exception for smaller condos to forego the committee requirement. So the only other option, if they really need to follow through with some enforcement, would be a legal process.
Okay. Let's see here. And how soon after a fine is issued can you assess additional fines if the fine is not paid?
So you can immediately, if there is a ongoing violation that's not resolved and you've levied a fine, you can start the process over. It's treated as a new violation, even though it's the same behavior. The first one happened, it accrued the max fine, it went through the process. And if that circumstance still exists, or that person does the same thing again in the future, you can go through the whole process again. You do have to go through the whole process, but you can keep doing it over and over and over again, and accruing more fines to that person. But if you're doing that, I would tell you that it sounds like the fining process is probably not being very effective for you with that person if you're having to go through it over and over again. And again, that's where you may need to engage the association lawyer to really get compliance, because ultimately a fine is just a fine. It doesn't stop the behavior. only a legal process can really stop the behavior that you're trying to correct.
Yeah. Can an HOA issue violation if infraction can be seen from across the lake from the HOA easement?
Across the lake, no. So the new statute says, and this person is getting at the statute from last year and this year in an HOA basically said that people can do whatever they want essentially in their backyard. They can build what they want, store vehicles, build a shed, whatever, as long as it can't be seen from the adjacent parcels or the frontage of the home. Now, that was extended this year to also be adjacent common property. So if there's an adjacent strip of common property behind the home and there's not a fence that's up on the backside, where if someone walks on that common property, let's say the lake, like the lake shore bed, if they can see it from there, yes, then that owner, you can still enforce against whatever they have in their backyard. But if that property backs right up to the lake and only someone way across the lake can see it, and the adjacent homes can't see into the backyard, and whatever we're talking about can't be seen from the front, if it can only be seen from across the lake, then no, because that is not an adjacent common area. That's a common area that's far removed. But a lot of times there are adjacent strips of easements or swales or shoreline that would, again, allow you to enforce. Again, that's a community specific issue.
Mm-hmm. Let's see here. Oof, so many. Let's see here. Let's see. Trying to find a good one. If the association is still under developer control, does the board meeting have to occur to impose a fine, or can the president give direction to fine without an official meeting?
It should be done at a board meeting, but if the developer board unanimously consents, then under developer control, they may have the ability to do that. That would need to be examined with their governing documents to see what it says in the bylaws and articles about board meetings while under developer control. Again, that's where you start to get into where I talked about procedural missteps. An owner's attorney might argue, well, this should have been done at a board that says the board has to vote on it. It should have been done at a board meeting, and that one board member should not be, making the decisions. So again, if a developer board's going to do that, at the very least, they should sign a unanimous consent. But I would advise more commonly that they do that at an open meeting. But importantly, while under developer control, they are going to need a committee of owners to ratify and approve that fine. So even if they approve it at the developer board level, they still need the committee.
And yes, I also got a few questions on here. I will be emailing out the PowerPoint, so you will get this presentation. So that will be coming along with the recording.
Great.
Let's see here. Let me look through.
One of the questions I saw come up, it said, where does it say in the statute that the board needs to meet? And the statute says for both of them, it says a fine or suspension levied by the Board of Administration may not be imposed, and it goes on to talk about the committee. So from the rest of the statute, we also know that boards are not permitted to vote by email. So the only way a board could levy a fine would be at a board meeting. Again, you could arguably use a unanimous consent to approve of it, but otherwise the board cannot email each other to approve of a fine. It either most commonly has to be done at a board meeting or a unanimous consent document that's signed by all the board members unanimously agreeing. Otherwise, it's got to be at a board meeting, because the board cannot levy a fine or vote on anything outside of a board meeting other than unanimous consent. And honestly, unanimous consent is not something that we advise using as a regular practice, because it circumvents the intention, the spirit and the intention of the law. It can be used, in limited circumstances, but it shouldn't be used as a regular practice for the board.
Here's another one. So at the board meeting to decide to find an owner, do you put the owner's name on the agenda that goes out to all owners?
I commonly, to give some degree of privacy, even though it's not a confidential matter, what I recommend on the agenda is that they list either the unit number or the lot number or the address rather than the name. So it gives some degree of anonymity, a little bit. But I do recommend that you put it on the notice. There's some case law that stands for the proposition that it should be, that some identifying information should be not just on the notice, but most importantly, in the minutes of the meeting. So it's common practice that we recommend that you have some identification on the notice and especially in the meeting minutes.
Perfect. All right, let's see here. Someone asked, let's see. So for example, you cannot, they asked another question, so that one went away. Sorry. Let me look here. Let's see. All right, can the board vote outside of the meeting and then ratify their decision at the meeting? My board meets quarterly.
No, I mean, again, the board legally, no, the board cannot make decisions outside of a meeting unless it's by unanimous consent in a written unanimous consent document. That doesn't mean an email. It doesn't mean a text that we all say we agree. It means a written document that's like a resolution that that all the board members agree on. But that should not be, again, I don't advise that as a common practice, but it is an option, that is potentially available, and it is a good idea as the individual reference to then later ratify it. But just the only way to vote outside of a meeting is unanimous written consent.
And do these rules, I know because we've really just touched on HOAs and condos, does any of this apply to co-ops? We've gotten a few of those.
The co-op, co-ops similar to condo.
Okay. Yep. And let's see here, when they reach the $1,000 in fines, do they start, how do they start the process again? Should they mail in the hearing notice again?
So when they've reached the $1,000 in fines for a particular violation, you can, if the issue is still going on, you can send a new violation letter, but you have to start from the beginning again. You send the violation letter, the warning, which again, your association can decide when it's a recurring issue that you're not going to send a warning. If you're not going to send the warning, then you still need to have the board vote, send the owner the 14-day notice, have the committee vote, send the owner the determination letter. And again, if they still don't fix the issue after all of that, you can start again with another one. So it can be 1,000. And then after you go through everything else, now 2,000. And then after you go through it again, 3,000 and so on. But you do have to go through the full process. There's not sort of like a shortcut to the board vote and the committee vote. For recurring issues, unfortunately. Again, I wish there were, but the good news is a lot of boards sometimes think that once they find an owner the $1,000 for a particular issue, that's the end of it, and the owner can keep having that problem persist without being fined again, and that's not the case. You just have to go through the whole process again.
Perfect. We want to do like one more here because it is 1 o'clock.
Sure.
This is interesting. Can a convicted felon sit on the fining and grievance committee if not all civil rights returned?
So I've had this question actually surprisingly before. The answer is the statute says that such individuals cannot sit on the board of directors. Now, remember, the board of directors are the individuals who select the committee members. And I would very strongly counsel, as I did with my client when they asked me the question, they should not be putting convicted felons who've not had their civil rights restored in such a position. I just do not think they should find other people. of course, once that person's had their 5 years, since their civil rights have been restored, fine. But again, I highly recommend against doing that. But the statute does not prohibit it.
Perfect.
I see here,
So,
I see a few more of these. I can just,
Go for it.
I see here, I'll just do these quickly. I'm just seeing at the bottom of the list here. Let's see. Can the board president make the grievance committee meeting a closed meeting? No, I'll do these as quickly as I can. Let's see. Can we collect fine money in small claims court? Yes. Is the point of the board meeting to have a hearing on whether there's an actual violation and the owner can present their side? No, not really. That is the committee meeting is really that. The board can choose to take the owner's information, but they don't have to. Can the same people sit on the violation and enforcement committees? I'm guessing the violation committee are the people who point out the problems, and the enforcement committee are the ones who levy the fines. I would not recommend they be one and the same, because obviously there's going to be a pretty good chance they're going to want to approve automatically anything that they originally cited. Can you give a warning based on a witness report without a photo? Yes, you can. I would just ask that the witness put an email or written something in writing to the manager, confirm, so that it's not just verbal, but you actually have a written record. Let's see. Can a board member sit on a fining committee? No. Can you decline the release renewal for continuous violations? If your documents allow for you the right to approve or disapprove, yes, then you could. The fining committee is composed of homeowners. Yes, they should be. They're composed of homeowners, correct? I see some nice comments for me. Thank you. I'll answer a couple more if I can here quick. Some of these are not fining specific. Would it be better to go the way of amenity suspension rather than a fine? There are some instances where it makes more sense to suspend amenity use rights. It depends on your ability. First, it depends on what amenities you have. Some communities don't have a lot of amenities. Secondly, it also, I would say, depends on your ability to easily suspend those. A lot of communities have modern like fob or electronic systems that they can easily suspend and turn off. But in other communities, it's very hard to police that. But suspensions can sometimes be the better option. That's really up to you guys to decide what's appropriate. For the 14-day notice, does that mean it's post-dated 14 days or the owner has it in hand? That means it's post-dated at least 14 days. So when the owner gets it, it might be 10 days before, it might be 5 days before. The obligation is to just put it in the mail at least 14 days before. Let's see. I think I've hit on a lot of them. So I think we'll cut it off there. Of course, if anyone are existing clients and you have questions, you can certainly follow up with me. For anyone who aren't clients, if you'd like to talk further, I'm always happy to talk to board members and help communities. And I'd be happy to talk to your board or your community if you'd like.
Thanks for watching. For more great educational content, click the subscribe button now.